All right. Hi, everybody. It's John Martin from the KJC Law Firm. I'm back after having my colleagues do the last couple of our little web series episodes. And with me is a very talented attorney named Paul Caruso, who also happens to be a premises security expert, and specifically an expert who advises and consults with colleges across the country regarding various ways that they can prevent and respond to sexual assault, which is something that is very important at our law firm with our sexual assault crisis response team and our sexual assault litigation team, and something that's very important for parents and students getting ready to go back to school. So Paul, after a very lengthy introduction, welcome.
Thanks, John. It's great to be here with you.
Yeah, I really appreciate having you here. So tell us about, I want to go into your background, but just first, why this is such an important topic. I was researching recently for one of my cases, and I came across some studies that shows that as much as 20%, or almost 20%, 1 in 6 women, students between the ages of 18 and 22 will be a victim of sexual assault on a college campus. Is that consistent with what you've seen in your work?
So that's right. During their college career, at some point during that time, they will fall victim to a sexual assault.
Unbelievable. And then I was also seeing that less than 5% will report it to an authority. So, you know, there's statistics that allow us to know how many are happening roughly, but as far as reporting it to the university, reporting it to the police, filing a civil lawsuit, that number is 1 in 5.
Sure.
I mean less than 5 out of 100.
That's exactly right.
Unbelievable. So before we dig into how those numbers got that bad and what colleges are doing to fix it, tell everybody what you do and what your role is on college campuses.
So I've done a series of consulting projects with colleges and universities across the United States, and helped them with public safety challenges that include everything from how to keep property safe to how to manage dissent on campus in a way that allows for expression but maintains safety of the premises, to compliance with Clery, the federal reporting laws, and issues like Title IX, which I think we're going to talk about tonight.
Yeah, exactly. Tell us, what is Title IX?
So Title IX was an amendment to the Education Acts. They had made, the Congress had made discrimination on the basis of race, creed, and color unlawful in educational environments, but did not include sex. And in 1972, after some amount of lobbying by interest groups, they passed Title IX, which made it unlawful to discriminate on the basis of sex by any program receiving federal financial assistance.
Now, one form of discrimination is harassment, which can you define for everybody what is sexual harassment in terms of the college setting?
So when we talk about harassment and it being discriminatory, harassment is unwelcome conduct. It's conduct that is has its roots in the sex of the victim, and it is pervasive.
So now, when we typically think of a sexual assault, we automatically think of criminal prosecution and arrest and proof beyond a reasonable doubt and all those types of things. Right. But one interesting thing about Title IX, and one thing that civil plaintiffs lawyers can pursue, or even disciplinary authorities on the campus, is that sexual assault is also a form of sexual harassment that violates Title IX.
That's right.
So what are the types of things that colleges are required to do in order to prevent and respond to sexual harassment or sexual assaults on the campus? Let's start with prevention.
So what they're required to do has changed just recently, in fact, last Friday.
Mm-hmm.
But the Department of Education, the United States Department of Education, has sent out guidance over the last, 9 years to colleges and universities, telling them what they are expected to do and what resources they have to make available, what sort of training that needs to be accomplished, and who on campus needs to be involved in seeing that this problem is minimized.
Mm-hmm. Okay. Now, my understanding is that there's been a lot of controversy. You mentioned that there was changes last Friday, August 14th.
That's
There's
right.
been a lot of controversy, but of course, during the global pandemic and an election year, not a lot of public discussion about the changes. And many people, myself included, believe that the changes to Title IX seriously degraded the university's responsibility to protect and respond to allegations of sexual harassment on the campus. What do you think, in your opinion? What are the change? What difference do these changes make?
So, and I hope I didn't misspeak. Title IX itself didn't change. The law is the same as it was when it was passed in 1972.
Mm-hmm.
There was guidance from the Department of Education in 2011 under the Obama administration that gave a specific roadmap to colleges and universities as to what they had to do to prevent and what they had to do to respond to complaints.
Mm-hmm.
That guidance was criticized for a lot of reasons, and one of the reasons it was criticized was that there was a belief that the regulations or the guidance from Department of Ed were tilted towards the complainant, to unfairly against the person being complained about. And so that was a criticism, and it was one of the things that the Education Department under the Trump administration tried to address.
Mm-hmm.
So they addressed it a couple of ways. First of all, they changed the rules regarding standard of proof. So you talked earlier about the criminal standard, beyond a reasonable doubt. And that is the highest standard in any judicial forum, because an individual's life and liberty are at risk on a criminal charge. And so we apply that very high standard. But in the context of a college or university inquiry, the risk of life changes is much different than going to jail. Will you be allowed to continue to go to that particular school? Is may be the limit of what's at risk. And so the standard of proof is different. Before the change in regulations last Friday, there was a preponderance of the evidence standard, 50% plus a hair, right? If you're just a little more certain that one side is in the right over the other, then you have met your preponderance of evidence standard. What they did under the new regulations is they added an option for schools to apply a clear and convincing standard, so that the complainant would have to show through clear and convincing evidence that the person being complained about had behaved inappropriately. And the only thing that is more interesting than you have an option as to what standard is that you have to apply that standard to all disciplinary processes. So if you're saying we need a clear and convincing standard for sexual assault, you also need a clear and convincing standard for your other disciplinary processes on campus.
So that's interesting. So for a couple of reasons, and starting at the end, they had to make sure that sexual assault had the same burden of proof as all of the other allegations.
That's exactly right.
So if you want to apply clear and convincing to sexual assault, you have to apply clear and convincing to everything: theft, regular assault.
And it's a tough standard to put your entire institutional complaint processes through. I am interested to see which schools adopt that and how they manage it. I'm fascinated to see that.
Right. And it seems like another issue with the burden of proof is, in many of these college cases, obviously there's alcohol involved.
Sure. Alcohol is an exacerbating factor, either alcohol being consumed by the victim or the individual perpetrating the assault.
Right. And every case I've dealt with, the university's policies have very clearly articulated that alcohol can play a factor in whether or not somebody even has the capacity to give consent. So there's a lot of fighting in these cases about, did the person consent to some of the behavior but not all of the behavior? Was the person incapacitated from consenting? Was the assailant incapacitating from, evaluating those things? And even in a preponderance of the evidence case, those things can be difficult. But with clear and convincing, it seems like unless you have a video recording or an eyewitness, there is no way to prove by a clear and convincing standard whether or not somebody did or did not consent to sexual activity.
I think it would be very difficult. I think it would be very, very difficult to prove it under those circumstances. Maybe not impossible, but really, really hard.
Yeah. Now, like you said, and I may have misspoke earlier, Title IX, the federal law didn't change, but the way that the Department of Education is instructing universities to respond to Title IX or to enforce Title IX under the current administration has changed. In court, in federal court and state court, plaintiffs' attorneys will still have the burden of proof of a preponderance of the evidence.
Absolutely.
Yeah.
Absolutely.
Which is interesting because most people hope that you could resolve this at the university on a private, kind of more confidential matter and not necessarily need to pursue something through the courts. But really, the most viable option now seems to be relegated once again to the courts, that the only place where you can really get a fair shake is in court.
This has become the Full Employment Act for attorneys. It really is just an amazing, one of the criticisms was that the earlier guidance from Department of Ed was it's too complicated. It requires too much process. Well, I don't see how this narrows the process. And when you think about it, we've isolated colleges and universities and are holding them to a standard of conduct that we would never hold any other institution to. Boeing receives federal money. You never tell Boeing to do this. But we're telling colleges and universities to set up these mini judicial systems. I think most of them are ill-equipped for it. We're going to be inviting attorneys into on-campus processes to participate fully in these issues that I don't see how most schools are ready for that.
Another thing I found shocking in the change this past Friday was the changes to the mandated reporter designations. Just for those who don't know, there's mandated reporters, which means that people who have certain positions within the university, if they become aware of sexual assault, whether it's by a staff member or a student, it seems pretty obvious they're mandated to report that, or they can be in trouble and the university can be held liable. But now that's changed as well.
Yeah, that's right. And so this is my personal opinion. I don't think this is a change for the better. A lot of colleges and universities had a blanket mandatory reporting approach that, with the exception of some individual counseling and pastoral care people, if you were employed on campus, you were a mandatory reporter.
Mhm.
That means that anything that you saw that led you to believe that an assault had taken place, you needed to report. And most schools had training to support that. The new regulations have really narrowed who is qualified to receive such a report. And I don't see how that protects the rights of the accused. I think it just makes it more difficult for victims, and unnecessarily so.
Well, one thing that just blows my mind, especially in the wake of the Paterno scandal and the United States Olympic gymnastics team scandal, is that athletic coaches are no longer considered mandated reporters, at least not by the United States Department of Education.
Yeah, that's
shocking.
well, it's just incredible. And I think a real vulnerability in the law. So not the law, the regulations. There's an awful lot of litigation pending, challenging these new regulations, and it'll be very interesting to see what effect that has. None of it has resulted in an order to delay the implementation, but there's a lot of meat to some of these claims, and I think that's one area that's going to be really problematic.
So, but just to be clear, what the Department of Education is now saying is, if an athletic coach, let's say head coach of the football team, is aware that one of the assistant coaches is abusing a student, whether as a one-time assault or repeatedly or serially sexually harassing someone, if they don't report it, they haven't violated Title IX. They haven't violated federal law, at least as far as the Department of Education is concerned.
That's right. So there's been no institutional violation of Title IX in that case. Now, there are other reporting laws. There's Clery. And it's Title IX and Clery used to be in lockstep. It appears that may not be true anymore. So it will be interesting to see if campus security authorities under Clery have a different reporting requirement than folks do under Title IX. I think it would be a shame if it turns out that they do, because that's unnecessarily complex, but that could very well be a result of this.
So how do you see this playing out in court? Because people like me are going to go to court and say, we don't care what the Department of Education says about their interpretation of the laws. It's up to the jury to decide whether or not this university allowed this child, or I guess some of them are adults, they're in college, so they're adults, these women to be sexually harassed by staff members. Are courts going to let those questions go to the jury, or are courts going to defer to the Department of Education's interpretation of the law?
So if I knew the answer to that, John, I'd be a much higher paid person than I am. But I don't think a jury will like to hear the answer, I didn't have to tell anyone. I really don't think there's going to be a lot of juries who like that answer. And I don't think there's going to be a lot of judges who like that answer. And so, whether this particular requirement or lack of requirement, if you will, becomes dispositive in a lot of cases, particularly involving athletic teams, I think it's early. There's all sorts of organizations that oblige reporting. NCAA obliges reporting. And so I although I regret this change, I'm not sure it's as impactful as we fear.
Mm. Yeah, I agree in terms of bringing a lawsuit for damages.
Yeah.
I think that you're absolutely right. The university, once on notice, has a duty to intervene and prevent. And I don't think that that's going to change. In fact, I think the Department of Education is setting a lot of these schools up for really significant verdicts against them. But it seems like what it's really done internally in the school has not helped that statistic that less than 5% people report when they're assaulted, because I mean, there's just no point to report it in the school. You have to do it by clear and convincing evidence. The entire athletics department is under no duty to intervene or help you. I mean, how much more can we do to discourage people from reporting these things?
Well, there's a reason why only 5% report, because reporting is just no fun.
Mm-hmm.
There's very little reinforcement to reporting.
Mm-hmm.
And it's a lot easier to just say, okay, I've been raped. I have to find a way to deal with that and move on, because the alternative, going public with it, is frequently horrible.
Mm-hmm. Yeah, let's unpack that, the trauma for a moment, the trauma of these events, because first of all, there's the sexual assault, but then there's a certain level of betrayal that people tend to feel, right or wrong, but from my perspective, it's usually been right, from people in authority, and then there's a certain stigma that gets attached.
There's tremendous
blame the victim defense, and there is a who cried foul, or it's just a really emotionally difficult thing to go through.
There's tremendous social baggage. Someone gets robbed, or there's a victim of some other crime. We rarely go at the victim. Someone gets raped, the first thing you think of was, what was she drinking? What was she wearing? What was she doing there? And what we're saying when we ask those questions is that there is permission to rape. If she's drunk, someone has permission to rape. If she is in a place that she probably shouldn't have decided to go, then someone there has permission to rape. Well, that's nonsense. The only thing that causes rape is rapists.
I can't say it any better than that. Exactly right. Now these things all apply for moving forward.
Yeah.
Looking backward in cases that we've already taken at my law firm, or other people may have with other law firms, those will be going by the old rules. Right. New rules moving forward. Still waiting to see how the universities are going to respond. What do you think is the right play or the right legal maneuver for somebody who has a loved one that's been the victim of an assault, or for somebody that has themselves been a victim of an assault after August 14th of 2020? What's the right legal move to make?
Right. So the first thing you have to think about is what's good for the victim. Because there is all this social baggage, and bringing a case either to trial or to adjudication on campus, or even to the police department, is such a difficult thing. We have to decide what's good for the victim here. And what's good for the victim, I am sorry to say, it may be not to participate in those things. But for those victims who feel that there should be justice done, that in order for them to move on, an individual has to be brought to account, then the first thing you want to go through is the school process, whatever the school process is. I think courts will want to see that you did that. And to the extent that there is an articulated school process, it probably should be followed. Many school processes don't cover people who aren't students anymore.
Mm.
And so if they're no longer a student, that's not an option. And so I'd go
Let me
civil.
jump in with a question. Sorry to interrupt. During this school process, the defendant who's been accused of the rape or the assault has the right to hire an attorney and
Sure.
be defended by an attorney, and they pay, you know, $300, $400, $500 an hour for a top-notch attorney.
Both sides do.
What's provided for the victim of the assault? Does the university provide a prosecuting attorney, or is there any fund, or does the complainant go through this process herself or himself?
That's a great question. So first of all, the university has an affirmative responsibility to decide what happened here. So they have to do some investigation, regardless of what the complainant or the defendant bring to the process.
Mm-hmm.
They've got to go and try to figure out what happened.
Okay.
So there's that piece, and there are people who are employed on campus either solely in that capacity or as part of other job responsibilities to engage in that inquiry.
Mm-hmm.
Each party, complainant and defendant, get to have an advisor. That advisor may be an attorney, probably will be in most cases, but it could be somebody else. My problem with attorneys getting involved at the school process is that the individuals managing that process have to be able to manage attorneys. They have to be able to manage the very common defense strategies of papering them to death, right? I mean, if I'm defending someone from an allegation like this, I'm going to do a lot of corresponding with the institution. I'm going to request data. I'm going to give data, and I'm going to be a zealous advocate at the hearing, because that's my job.
Mm.
And I worry that schools are not in a position to manage that.
Interesting. And the advisor that the victim is entitled to, that's paid for out of their own pocket?
That's right. So most schools provide an advisor for neither.
Mm-hmm.
And it's an option available to both.
So generally speaking, what's happening is the school is trying to manage this judicial process where they're the decision maker and the investigator.
Yes.
The defendant has an attorney that's being paid for to protect their academic rights and their personal rights and all those things. And the complainant has the option of either going through this by herself or paying out of her own pocket to hire an attorney to advise her through the process.
That's right. Both sides have to pay for their own advisor.
Okay. Interesting. But then, of course, a civil lawsuit is a different scenario.
Sure is.
Okay. And can you explain to everybody what's the difference with a civil lawsuit? And I'm smiling because at least there's an opportunity at some point for the victims to flip the tables.
Sure. Yeah.
So I'm happy to finally get to that part.
You file suit in state or federal court, alleging that this tort has taken place, and perhaps this violation of Title IX has taken place, so now there's the discovery process that the defendant is obliged to take part in, and that's less comfortable. You've managed discovery processes. You ask a lot of difficult questions, and now it becomes a situation where individuals have to decide: is this a defendable case, or is this a case that's going to cost a great deal to defend? And should I exit earlier? So that's right. There's a power dynamic that doesn't exist on campus.
And the victims if they go to the right law firms, don't pay anything out of their pocket. They only pay if they prevail.
That's right. That's exactly right.
Yeah.
That's,
yeah. And then, probably the most important topic, and I promise I won't keep you all night, but I think the most important topic is with your expertise and having seen and investigated so many of these instances and these campuses and these different, response mechanisms. What are the 3 best things that a student or a parent of a student can do to prevent something like this from happening in the first place?
so prevention is hard, but I think that whether it be student, parent, or institution, the idea that people talk about these problems on campus as a way of bringing sunshine into the issue is huge. So education, discussions about the realities that people face, that's a big deal. If we can get to students and get them aware of this problem before they are victimized, it's a big deal. The idea that there is bystander responsibility. So people should feel empowered as bystanders rather, to stop something before it becomes a problem. There's a lot of good bystander programs on college campuses. And then counseling and support services that can deal with the traumatized victim. And the traumatized brain and the traumatized victim are important parts of this process, and we need to have trauma-informed investigation and adjudication.
Well, I thought that was really an enlightening conversation. Thank you. I know that you've spent a long time becoming an expert in this, and I really appreciate your time tonight. So thanks for coming in.
Always a pleasure, John. Good to see you. You look good.
Oh, now you're getting full of it. All right. See you, Paul. Thank you.
Bye, John.